Good evening. Thank you all for being here with us today. We are pleased to welcome you on the first event of CJA CBMA International Brand for the year of 2023. First, we would like to introduce the committee and the brand to those of you who aren't familiar with our work. The CJA CBMA is a committee for young arbitration practitioners of the Brazilian Center for Mediation and Arbitration, which aims to promote and disseminate arbitration in Brazil through lectures, courses, workshops, and study groups, and such as study groups.
The international branch of CJA was born in 2021 with two main goals. First, to introduce topics of international arbitration to our members and guests. And second, to propel our members and the community of young Brazilian arbitration practitioners into the international arena. In that sense, we try to choose intriguing topics that will expand the viewers' knowledge on international arbitration, may it be on procedural issues or merits, as today, and invite international speakers that not only possess great knowledge on the topic under discussion, but also the arbitration market. To help us create more and more events that met your needs and expectations, we have created a quick form that we kindly ask you to answer that we have just pasted in the link in the comments in the Zoom. So please, if you can, try to respond this form so we will be able to make more events like this according to your needs and expectations. Thank you.
Today's topic is very dear to us and has been under development for some time, which is the arbitrations of disputes in art law. Although somewhat unknown here in Brazil, arbitration of art has had great growth internationally, being that there have been specialized chambers. Thus, today we will discuss the introduction to art law, arbitrations of art disputes and its market, the intensity of artworks covering fraud and falsification, and arbitraging arbitration, choice of law, the city of arbitration, and to that end, we are very honored to welcome our great speakers, Sra.Marta Cenini, William Charon, and Thomas John.
Introducing you, Marta Cenini is based in Milano, Italy. She's a private wealth and art law lawyer at Vicari Avvocati, an art arbitrator affiliated with CAFA and Venice Chamber, and a professor of civil law at Insubria University. She also holds a PhD in civil law from Turin University and Master of Art from the Goldsmiths College, University of London. And last but not least, she is a former pianist.
Thank you.
William is based in New York. He is a co-chair of art law group at Prior Cashman Law Firm, arbitrator affiliated with CAFA, and an adjunct professor of art law at the University of Virginia School of Law. He has been awarded a super lawyer since 2013 by the New York Metro List. He likes to be called Bill.
Thank you very much for inviting me. It's a pleasure to be here.
Last but not least, Mr. Thomas John. He is based in Delft, Netherlands. He is an independent art mediator and arbitrator. He is a local part for Thames art lawyers and professor for mediation at Sigmund Freud University. having more than 20 years of experience in conflict and dispute resolution in the private sector. He is specialized in arbitration at the University of Queensland and mediation by the CR. He describes himself as an art and carnival love. Please welcome all.
Thank you very much for having me.
Ms. Marta Cenini, you may begin.
Yeah, thank you. Thank you so much, Victor. Thank you, everybody. I'm so happy to be here with you to speak about art, law, and arbitration. I thank you so much, Victor and Taina, for inviting me. And I thank also the guest speaker to whom I will share the panel tonight, because I'm Italian now. It's night in Italy. So I would like to share PowerPoint with you. So I hope to be able to do that. Yes.
Yes, of course.
Of course, I open it and then I try to share it. Okay, here we are. Okay, perfect.
Yeah, we are seeing it. Thank you.
Okay, thank you so much. So please interrupt me if there is something that it's not working, and afterwards, of course, for any question. So is this Da Vinci Real is the name of this webinar, Arbitrating Our Law Disputes, and I will speak in particular about what is art for the law and what is art law. So it's a short introduction of what is art law, and then I will say to you 2 points about arbitration in art law dispute, and then I give the floor to the other speaker. So what is art for the law? Because I know that some of the person who are attending the seminar maybe are not so in depth in this kind of thing. So I would like to give you a short introduction about what is art for the law. Okay, let's start. So from the very beginning, this, of course, from the legal point of view, is a cultural property. Leonardo, Mona Lisa, maybe the most famous painting in the world, probably. You know that it's not in Italy, it's in France, in Paris. This, of course, according to the law, is a cultural property. Then we have here another very famous piece of art, maybe most of you knows it. It's a work of Damien Hirst, who is a very famous young British artist from Goldsmith College, so the college where I attended my master in contemporary art. So I wanted to start with a piece of him. And again, this, of course, is art, but it's not a cultural property according to the law. So we have to understand why there is this difference. This is one of the most expensive piece of art in the world, probably. And so it's also interesting when we will discuss about art market, not only about art law in general. So the difference, which is the difference? Works of art, of course, everybody who is, passionate about art knows that it's not easy to define what art is in general. And so we can start saying that artwork is any piece of art according to the definition of art given by art historians and by art critics. And as we have just seen, a piece of art like the School of Damien Hirst is extremely valuable. It was sold for an amount of money which is really incredible. But nevertheless, it's not considered a cultural property. This is a technical topic. What is cultural property then? Here we have a painting by Raffaello, again, one of the most important painters maybe in the world. This for sure is a cultural property. Why? Because it's considered a cultural property according to legislation. In particular, there is a set of legislation, national legislation. Italy has its cultural heritage code. France have similar cultural heritage code, and so on and so forth. And these are pieces of art that are considered relevant for the national heritage. Then we have also a notion, more international notion of cultural heritage, you know, UNESCO and so on and so forth. But let's stay on a national level. How can we distinguish between cultural property and art, generally speaking, according to the law? We have, of course, many different criterion to distinguish. In Italy, but we could say the same in France, the cultural heritage code usually says a series of elements that define the cultural property. Some of them are very easy. The first one is all the paintings or the piece of art that are already in a museum, in a public museum. This is the easiest definition of cultural property. If a cultural property, a painting, and so on and so forth, is already in a public museum, this automatically becomes a cultural property according to national law. Then we have other criterion to detect and to understand which is a cultural property. In that case, it's not so easy because they can also be, for example, private properties. So not only public property, but also a private property, a property that is already owned by a private person may be considered a cultural property. When this privately owned property is considered by the authority. In Italy, we have a sovrintendenza, maybe you have heard of it. The sovrintendenza look at the piece of art and says that that is a cultural property according to the law. When the sovrintendenza say this piece of art is considered a piece of the cultural heritage of Italy and becomes, in a certain sense, belonging to the cultural heritage of Italy, or similar. We can make a similar discussion with France and other states that have similar national legislations. When we have public properties, all the paintings, piece of art that are already in public museums, and these private property that belong to private person but are considered culturally relevant for a nation, what happens then? We then consider the piece of art, this cultural property, as restricted. In what sense? The most important restriction regards the circulation of this cultural property. Just to give you an example, a cultural property, if it is a public property, we are 100% sure. If it's a private property, we can also have some exception. But a cultural property, for example, cannot be sold freely. You cannot sell Raffaello, Leonardo, which is already in a public museum, freely. You cannot. Actually, some Leonardo and Raffaello, the pieces of the paintings that I was showing earlier, cannot be sold at all. It's not possible. They are cultural domain. It's this definition of cultural domain, which include all the piece of art that cannot be sold at all. Another characteristics, this piece of art cannot exit the national boundaries. So the circulation also abroad is restricted. So they cannot be sold, or they cannot exit the boundaries, or even temporary. If they go out just for an exhibition, it's necessary to ask for specific permission. So they are restricted. For this reason, we speak about a restricted or restricted assets property with cultural constraints, because this gives the idea that this piece of art cannot circulate freely. Then we have art market. Our market regards all the art or the piece of art which are not considered cultural properties according to these national laws. Here we have a picture of Christie's. We could mention many other auction houses. And so generally speaking, art market regards these unrestricted artworks, the artworks that are not considered cultural properties. Here we have the largest definition of art. We can have paintings, we can have digital art, we can have NFT, we can have more traditional paintings. Any form of art can be, of course, object of a sale within the art market. They can circulate freely, they can be sold without any restriction. Just to give you some numbers, here I put an image of the Art Basel. Art Basel is the most important, most famous art fair in the world, in Switzerland. And according to a report of Art Basel, the most important art fair in the world, the US is the largest market, with sales that have reached $22 billion. And then we have China and then UK, according to this report. The numbers are very, very high. It's quite impressive. Let's come back to the diamond skull, just again to give you an idea. Diamond skull by Damen-Hirst is covered by 8,000 diamonds, more than 8,000 diamonds. So just for making it, Damen-Hirst spent 15 million pounds. So just the materials for making diamond skull. But then it was sold for 100 million pounds. Just this piece of art, which is not a cultural property. So you see, this is, I think, it's very important to stress, because we think of Leonardo, Raffaello, Michelangelo as the most important artists in the world. Maybe they are, but it's maybe weird, but that piece of art cannot be sold. It's not possible to give a value to that piece of art. By contrast, we have all the contemporary art, all the other art which is not restricted by cultural constraints, that can be sold freely in the art market, and they can reach this astonishing price. I've put here some other very famous example: Rabbit by Jeff Koons, digital art. This is another very, very astonishing auction sale in 2021 during the pandemic, because during the pandemic, the online sales was very, they grew incredibly. And again, this digital art was sold for almost $70 million. I don't know, dollar or pounds, I don't remember, I'm sorry. And here I also put a short history about these artworks, because it was incredible how it changed from the starting points. It was just $100 and then reached $70 million, so something incredible. NFT, nobody knows exactly what NFT is. Actually, I don't for sure. But again, NFT now, it's so, maybe William can tell us, NFT now is growing so importance, and then they also for the art market again. So again, I put an example in 2021, sales of NFT art was $11 billion. So again, it's a price which is very astonishing. Some cases, because I also now we can move to what art law is, so we can move to more specific and more technical problems, technical issues. What art law is? I would like to show you a couple of cases, not so easy, not so difficult in the middle, just to give you an example. These are real cases. An artwork is sold by a merchant who guarantees that the author of the painting is a famous artist. This is a Monet, of course. And that was previously owned by the famous collector Alpha. After the sale, the buyer goes abroad and tries to resell the painting, but he cannot sell it. Why? Indeed, the potential new buyers, the one who are abroad, dispute that the painting was not made by artist X, but by artist Y. Of course, it's just a case. It had belonged to Alpha collector, but previously it was looted by the Nazis, and then it was damaged during the travel. A very easy case, not so complicated, but I think that it can show you some issues that can come up very, very often in art law disputes. First of all, question of authenticity of the artworks. So who is really the author of the painting? William will talk about it in more details, so I don't want to say more about this. But first of all, in the art world disputes, the first thing is that to understand who is the author of an art of a painting. The image was a Monet, it's a true Monet, so it's again a case, we are just discussing it, but the first issues in art law dispute is authenticity of the artworks. Who is the author? And we will see that this is a very complex case. It requires, of course, art historian competences. It's not just a lawyer, for sure, that can say who is the author of a painter, of a painting. And so again, so in this case, arbitration could be very useful, because within an arbitration, you can have more experts within the same dispute, the same case, that can help with different knowledge to understand and to solve the art historian problems and also the legal problems. Provenance, chain of transfer of property. I come back to the previous slide. Here we have this collector Alpha, but then it was discovered that the paintings was looted by the Nazis. Maybe some of you knows that there is this big issue nowadays, and you will read a lot of news in the newspaper about this, because you know, during the Nazi regime, many pieces of art was looted, and then as they are movable property, there was put and was stolen, was looted by the Nazis, and then exported abroad, and then now they are in the collection museums, and then they are in private collection. They are all over the world, these paintings. And when we discover this, when this piece of art, the collector wants to sell this piece of art, and then if a serious buyer or a serious merchant or a serious auction house make this so-called due diligence, maybe it's discovered that this painting was looted during the Nazi regime. So provenance, the chain of property. If we want to do something correctly, we have to understand which is the chain of transfer of property, and to understand who is the previous owner, but also all the chain of transfer of property. And we can come back to this Nazi period where many pieces of art was stolen, was looted, and so on and so forth. Then in the case, we have another problem. The painting was damaged during the travel. Again, it's a legal question now. Again, it's legal issues because of there is also many problems when we have to move the paintings, and when we have to to move from the place where they are to an exhibition, if we wanted to move them and maybe abroad, and so on and so forth. And this is another very technical area of art law related to transport, contract of transport of paintings, and also insurance. Insurance in the art world is something that's growing much importance, and there are specialized insurance companies that are dedicated just to give insurance for moving artworks, because it's very complex. It requires specific competence, because it's not so easy to move the painting, because it could be a painting, it could be something more difficult to move. It requires technical competences, but also it's difficult to value and to give a price in case of damage. It's difficult to assess the damages, and so on and so forth. So again, it's a very specific area of art law. So what this very easy case involves many areas of law. First of all, we have seen contract law, for sure, contract law, sale law, contract of transport, insurance contracts, so all the area of contract law. Many art law disputes regards contracts. It's from a point of view, they are very similar to a classical dispute of contract law. Then we have some peculiarities, because the property object of the sale, of the transport, of the insurance is a cultural property or an artworks in general, but actually they are just commercial contracts. Then we have the area of property law, which in my opinion is maybe more complex, because generally speaking, property law it's most difficult for me than contract law, generally speaking, because it requires understanding exactly what is ownership, the chains of transfer of property, as we have seen, all the rules all the rules which the rules of bona fide purchaser, of value, for example, of possession, what means to possess a property when possession becomes ownership. As artworks, as said, is a movable property, most of the time we have to apply a rules of possession more than ownership. So especially if maybe the artwork was stolen. In Italy, we have, for example, a rule that says that even if the artwork is stolen, you can acquire the property, you can acquire the ownership if you get possession in good faith. Last but not least, international private law. International private law, why? Because again, it's a movable property. The paintings moves. And then maybe the first contract is in Italy, and then another contract is in France, in Switzerland. We have to understand the possession, the bona fide purchaser, where he purchased the property, and then if it's a transport contract, we have to understand which is the applicable law to the specific case. It's not so easy. It's very complicated. There are specific international private rules, and then we have also the international convention, because now, of course, it's just an introduction of art law, but there are many international conventions, European convention also, that gives us some other rules, which is not only international private law, it's more just international convention, but we have also this international point of view that we always have to consider when we are speaking about an art law case. Due diligence, I was referring to it earlier, because nowadays the art market especially is trying to teach or to introduce this knowledge of these issues related to provenance, especially of artworks. So there is this very interesting group of people who have created these guidelines about art transaction in order to try to list the questions and list to the areas that must be considered when we want to purchase an artworks with a knowledge of what we are purchasing. So it's divided into three parts: client due diligence, artwork due diligence, and transaction due diligence. I suggest you to have a look to this link that I copied it for you, because I think it's a very important project that could really teach us, or at least to improve more transparency in art law market, in order also to avoid this question of provenance, the question related to the Nazi looted art, and so on and so forth. Case 2. This is a painting of Cima da Conegliano. It's a case that I've discussed in front of the national Italian tribunal, and we are still litigating about this, so I can just tell you the starting of this case, but we have to wait for the result, for the judgment of the case. It's Cima da Conegliano. It's a painter, an Italian painter. Famous but not so famous. Maybe you have not have ever heard of him. I think it's beautiful. It's not that, of course, the painting that is object of the dispute, but it's similar. What was the case here? This Cima da Conegliano was privately owned, so it was in a private collection. It was then stolen and then exited Italy without permission. So here we have a case of the law applicable to the exportation of a painting. But the question is that this is a painting by a painter who is famous, is very much recognized by Italian Sovrintendenza, Italian authority, but was not already restricted. It was not already recognized as a cultural property. Okay, so it is, if you see it, you would say, yes, of course, it's a cultural property, but the Sovrintendenza had not already put these constraints on that property, and then exit Italy. He arrived to Switzerland, and then he went to London. He went to London, and then at that moment, the current owner by that time wanted to sell it, and he wanted to sell it through an auction house. So in that case, the auction house usually make photos of the painting and print the catalog of the auction and so on and so forth. So the true owner discovered that his painting was in London, and he was a little bit surprised and asked for restitution of the painting. Asked for restitution, and at the same time, the state asked for restitution. Even if it was not with this cultural constraint, the state asked for restitution of this painting, because it said even if there was not this cultural constraints, I think that this kind of painting is so important for our culture heritage, that must come back to Italy. So another case, very, very common case. The question here is, I want to stress with you, is that in Italy we have so many paintings, too much maybe, I don't know. Victor was saying that earlier. We have so many pieces of art, incredibly beautiful piece of art, ancient piece of art, but not all of these pieces of art are already looked by the Sovrintendenza, and so sometimes we have a piece of art that is privately owned, and it's very important according to our cultural heritage code, but Sovrintendenza has not already considered it as part of our cultural heritage. So in that case, since our Sovrintendenza wants to protect, at least they say that it's a question of protection of this property, they try to ask restitution, or at least to get this kind of painting, or at least to put the constraints of that paintings. Of course, it's a question between protection, again, if we say this, I can agree with this, protection of cultural property on one hand, and then by contracts improving, or at least try to enhance art market, because as said, if we put these cultural constraints, actually the paintings cannot be sold, cannot be exit permanently. It's death in a certain sense. Again, which area of art law it's involved in this case? Export law, cultural heritage code, contract law, and property law. Again, contract law, because the piece of art, the painting, was about to be sold. But property law, for the reason that I was mentioning earlier, because this piece of art was stolen, exit the boundaries of Italy, and then maybe it was sold abroad. And so we have to understand, according to property law, because it was sold, and so the seller was not the owner of the property. Okay, it was sold abroad, and when we understand the applicable law to that sale in that specific place, according to property law and according to international private law. Then we have this International European Convention on Restitution of Cultural Goods. So UNESCO Convention, Draft Convention, European Directive, all these conventions state that the cultural property, the cultural goods must be given back to the country of origin. But again, this is a huge debate about this, and today we don't have time to discuss it. It's another seminar, another webinar about this. But what I want to stress again another time, and then we can move on. It's the question that in Italy we have these paintings that are not always already considered cultural goods, but nevertheless the state says that actually they are cultural goods, so they ask for restitution. Okay, so it's very complicated. And now this last slide, and I give the floor to the other guest speakers. Why so arbitration is so important in art law disputes? It's so important, first of all, expertise. Art law is so complex. I just showed you a couple of examples, and it's so technical, so complex. It's so complex area of law. And also, as said, implies the involvement of many other different expertise, art historians, art critics, forensic science, material analysis expert, because they have, for example, to understand which was the prior status of the artworks. Let's remember the example of the paintings that was damaged when they was transported to another place. So it's necessary to understand how was the status of the artworks previously and then after the travel, for example. So it involves so many different expertise, and so a national court it's not possible to have this different expertise within a traditional judgment. Provenance research is so complex, and I was saying earlier that this Nazi looted art, it's now very it's exploded in a certain sense. There are so many cases. So you will, if you have time to give a look, there are so many news in the newspaper about that, and so it's so complex to research and to understand all the chain of transfers of property, and most of the time it's discovered that the painting was looted and so on and so forth. And then confidentiality, because very often the artworks, especially if they are in a private collection, it's owned by a person that don't want to be exposed by newspapers, by news. They want don't want to have their case on the newspaper. And so they prefer to have an arbitration because they want to be protected by newspapers and so on and so forth. So I think that these are the two main reasons the two main reasons for which arbitration is the best solution in an art law dispute. So thank you so much. Thank you so much, really. And I hope that this will be just a first occasion, and I give the floor to the guest speakers, the colleagues, and thanks again for inviting me, and good night, because it's midnight now in Italy. Good. Bye. Thanks so.
Thank you.
Thank you so much.
It was a very rich speech. I have to say that I learned a lot, and I believe all of us have learned a lot from you. So giving the floor right now to Mr. William. Bill, please.
Thank you very much. So as Marta pointed out at the start of her presentation, there's no great definition for what art is. My favorite definition is actually simply art is. But one of the things that art is these days is money. For sure, people collect art for art's sake, but no shortage of people collect art because it has become a commodity, and it can be quite valuable. It can be quite valuable if it's genuine. If it's a fake or a forgery, the value can go from many millions of US dollars to zero. So the problem of fakes and forgeries is one that really pollutes the market. It's quite prevalent, and it's a serious problem. And it can lend itself to many different kinds of claims. Some of them can be in contract, such as a breach of a warranty of authenticity, that a work is by the artist as represented, or other claims are known as mistake of fact claims, where the parties are mistaken, but nonetheless can undo a contract. Other claims can sound in fraud or negligence, and that you are aware, knowingly aware, that a work is not genuine and you're selling it anyway at an exorbitant price. Some claims can be in the nature of a false advertising claim or a false marketing, and others can be in the nature of antitrust, where if you decide to bring a work to an expert, a recognized connoisseur, expert, or foundation of the artist, and they are still willing to offer opinions of authenticity and they decline to opine that the work you have is authentic, you may be angry and you may sue them. And you may sue them claiming that what they're trying to do is corner the market for their own inventory that they're selling. So these claims can take on many different faces. And if you are a defendant in one of these claims, there are two reflexive defenses you're going to bring. The first is prove that it's a fake. That's really, really difficult to do. There are generally recognized three ways through expertise to prove that a work of art is fake. It's referred to sometimes as the three-legged stool of authenticity. And the disciplines are provenance, connoisseurship, and science. Each has its virtues, each has its limitations. Provenance, Marta discussed provenance in the context of title disputes where it's essential, but provenance is also important in authenticity disputes because it is a way to demonstrate it's evidence of authenticity if you can establish a chain of title that goes back to the artist, her or himself. If you can literally put that work of art into the artist's studio upon good evidence, that's excellent evidence that the work was in fact by the hand of that artist and authentic. The problem, of course, that can be done oftentimes with living artists. It becomes much more difficult with deceased artists and the further back in time you go. And so when you have gaps in provenance, you have a limitation on the quality of that evidence to prove authenticity. Science is another means to prove or disprove authenticity, disprove being the key term. What science will do is it will examine a work at a molecular level for what are known as anachronisms. So for instance, I buy a painting that purports to be by, say, Mark Rothko, created in 1956. And the painting has a particular red pigment on it. Scientists can analyze that painting and detect that the red pigment on the painting was actually not commercially available until the 1960s. So the fact that it says it was created in 1956, but the pigment wasn't on the market till the 1960s is evidence that that's a fake, that's an anachronism. And the available science is really, it's quite remarkable because there can be radiocarbon testing of the canvas, which is cotton, harvested cotton. And so when back in the days when there was nuclear testing in the atmosphere, that radiation seeped into the cotton, and you can test to see if a radiation level in a canvas is consistent with the time period. whether there was nuclear testing allowed or not. So science can be excellent. And of course, there are other ways you can test the signature to see if it's really by the artist. And once again, if you get evidence that it's not, that's an anachronism. So science can be very helpful to prove that a work is not authentic. What science cannot do is prove that it is authentic, because you might have a very skilled forger. There's a well-known case of a forger named Wolfgang Beltracchi, and he was cunning enough to hire his own scientist as a consultant to issue spot for him, or try to prevent him from falling into traps where he might use the wrong pigment. His consultant missed something, and a white pigment ultimately brought him down. But science cannot prove that something is genuine. It's really limited to proving that it's not genuine. Also, scientific testing is very expensive. And it's not the kind of thing that if you walk into a gallery and you're interested in buying what is being marketed as a Picasso, to tell that dealer, look, I'm interested, I might spend a few $1 million on this, but would you let me first have my scientist test it, which involves scraping the work and at a very fine level, to be sure, but nonetheless, it's invasive work. A dealer is not going to be too thrilled with the idea of the work leaving the gallery with all sorts of transportation and insurance issues and being tested. So science has its limitation. And so then you have connoisseurship, which I think the market generally will recognize as probably the best quality of evidence if you can find a recognized scholar or foundation for the artist who will offer an opinion based upon their expertise that the work is right or not, that it's by the hand of the artist. There are, and if you can get that opinion of authenticity, and in particular catalogs raisonné that identify works of art, that's really kind of a go-to if you're going to bring a work of art to a major auction house like Christie's or Sotheby's. The first thing they're going to do is say, well, is this in the catalog raisonné of the artist or not? So if you can get that evidence, you're in very good shape. Two problems. One, connoisseurs are more and more frequently not willing to offer opinions these days because they get sued for their trouble. There's a nightmarish case in the US involving the Andy Warhol Foundation, where they refused to offer an opinion of authenticity. They were sued under some of the theories I described at the start. And they prevailed in the case, but it required millions of dollars in legal fees to do so. And so in the category of no good deed goes unpunished, you're seeing a lot of connoisseurs opt out of giving opinions, and it's just harder to get. The other problem with connoisseurship, and this is more of a problem from a judicial level, is unlike science, which is more objectively, there are objective standards and it can be tested, and courts can kind of look at rules to follow and determine whether they were followed. A connoisseur can look at a work of art and in a matter of moments declare it to be right or not right, authentic or inauthentic. And if you ask that person, well, how do you know that? Oftentimes the answer will be, I just know. Take my word for it. I'm the expert. And the market, once again, may credit that, but judges can have a hard time crediting that because they don't understand it. One thing that US judges hate is people getting up and claiming to be experts, and they can't really explain their methodology. They just say, take my word for it. I know it when I see it. So that becomes problematic as a form of evidence as well. So once again, if you're a defendant in a lawsuit contesting authenticity, the first thing you're going to do is tell the plaintiff, good luck proving that it's a fake, because you're going to have all these problems and all these limitations. But let's say you can overcome those problems and limitations. Let's say you do have excellent evidence that it's a fake. Now, if you're the defendant, you've got curtain two, your next line of defense, which is blame the victim. Okay, I sold you a fake, but it's your fault for not detecting it sooner. You should have done a greater level of diligence to have figured this out for yourself. And here, you can have, Marta had mentioned choice of law, and I know Thomas is going to speak more about this, the choice of law issue in particular, but different jurisdictions. So the art world, I like to say, is small and flat. Art can move internationally with relative ease. And so, but when it does move, it starts triggering different laws of different countries and jurisdictions. Whose law is going to control the question of what kind of diligence should have been done? Marta mentioned in the title context that certain jurisdictions in Europe will allow good faith purchasers of even stolen art to retain the art. But in the US, generally speaking, even if you're a good faith purchaser, if a work of art was stolen by Nazis or otherwise, you have to give it back. Your good faith won't save you, even if you've paid millions of dollars for it. So the choice of law can be very important. The same is true in authenticity disputes, and how the jurisdiction whose law controls is going to govern, well, was it the dealer's fault? Was it the buyer's fault? Can be very important. I just wrote an article about this earlier this year for the Art Law Review, and it evaluates how burdens of diligence and risks of loss are assigned in the US in authenticity cases. And you've really got two ends of a spectrum. On one end, there's a well-known case here involving a gallery that purchased a claimed painting by Milton Avery. There is a foundation, the Avery Foundation, that will authenticate still whether a work is by the artist or not. The gallery in this case, known as the ACA Galleries, purchased the work for $1 million from a guy in North Carolina that no one had ever heard of. This was not a known dealer. But what the gallery did was they decided to buy it, and then they submitted it to the foundation for an opinion of authenticity. And the foundation said, no, we're not going to certify this. So they'd spend $1 million on a fake. They sue the seller for selling them a fake. And the courts come down and say, nope, it's your fault, gallery buyer, because you were basically gambling. You knew there was a foundation. You could have done more to protect yourself. And in the United States, we feel very strongly about a doctrine known as caveat emptor, or buyer beware. And we really place a lot of burden on buyers to protect themselves. So the gallery's lost, sorry. And the no-name seller in North Carolina went on his way with $1 million. At the other end of the spectrum, you've got a case that I was involved with, representing a buyer of a fake Mark Rothko from now closed, defunct, but very famous gallery at the time known as the Knoedler Gallery. It was the oldest, most reputable gallery in the US. It had been around since the mid-1800s. And that was really a highly reputable dealer. And that's where you would go if you had a spare $10 or $20 million that you wanted to buy a Jackson Pollock or a Mark Rothko or a Robert Motherwell. Our client, the Hilti Foundation, the Hilti Tool Company, purchased a Rothko for $5.5 million from Knoedler, and it was fake. We were able to prove that it was fake. So the defendant goes to its second line of defense, which is, well, blame Hilti. You know, Hilti's rich, Hilti's sophisticated, he's got a large art collection. He could have and should have figured this out for himself. And what we argued and prevailed upon was that there's a difference between going to a no-name seller in North Carolina and gambling, and going to a reputable dealer like a Knoedler Gallery, which is kind of top of the food chain, and relying on their good word. And here, you really have to, what becomes quite important are the particular customs and practices of the art market itself. Because, you know, the argument was made that wealthy purchasers and collectors of art will spend more time doing due diligence into a new car. They'll test drive a new car. They'll really, you know, they'll do their homework on the new car, but that's tens of thousands of dollars. But with art, they'll drop millions of dollars without doing anything of the sort, and that's just not fair. And that was, in my opinion and in the opinion of the court, thankfully, a very superficial argument, because you can go to a car dealer and you can take your time because you don't have to buy that car. You can come back and buy the same car, but there are multiples of the same car. If you want to go buy a Rothko, there's one Rothko. That's it. And the dealer is going to apply a lot of heat to this transaction. You got to do it now. I've got 5 other people interested in buying this. I'll hold it for 48 hours or maybe a week or maybe even a month, but you got to act soon. And the market is simply different. Plus, as we all know, anonymity is prized in the art market and commonplace. So if you wanted to go buy a house or a car, you would need to know who the prior owner was. You'd need to be able to do that diligence to protect yourself. But you go to a dealer like a Knoedler and they tell you, well, I can't tell you who the current owner is, but take my word for it. I'm Knoedler and this is a Rothko. You should be able to rely on that. And the court agreed. So again, the distinction between your particular situation and how the court is going to view your risk of loss and your burden of diligence can be very important. And so that takes us to the founding of the Court of Arbitration for Art, or the CAFA, of which I, am quite privileged to have been a founder of and to be an arbitrator in and a board member of today. But the idea behind the CAFA was it actually started with authenticity disputes. It has become it is a forum to handle all manners of art disputes, title disputes, copyright disputes, contract disputes, what have you. But it started with the idea of authenticity disputes. And the idea was to have a specialized forum that could flatten the learning curve in these cases. You could have practitioners, art lawyers, people who practice in this area regularly, who are very familiar with the particular legal issues that abound in these cases, but are just as familiar with the customs in the art market and the peculiarities of the art market, and that they would understand how to weigh those and factor them in a way that would make sense. There are multiple cases in the US in authenticity disputes where you have a situation where a provenance researcher has come in and put in a report that says, I believe this work is authentic because it's got a clean provenance and I can trace it back to the artist. But you've got a connoisseur of the artist, or maybe even the artist him or herself, disavowing the work, saying that is not by the hand of the artist. So of the 3-legged stool, you've got 2 of the legs competing with one another. The market, and these cases, you'll have courts that will say, well, there's at least a real genuine dispute here because the provenance evidence is so good. Or maybe the court will go all the way and issue a declaration that I think, at least to a more likely than not standard of proof, this is authentic. But if you've got the connoisseur saying it's not authentic, then it's a very unsatisfying victory for the owner of the work in the court case, because you get a piece of paper saying it's authentic, but there's nothing you can do with it. The market is not going to touch this if you've got the artist or the connoisseur disavowing it. And so the lack of appreciation of that dynamic can be a problem in these cases. That was something we were hoping the CAFA would be better equipped to handle. So there were really, 3 key ideas behind the CAFA. One was you would have arbitrators who are specialized in the area of art law and would be able to kind of hit the ground running and understand what these cases are about and understand how to value the evidence that's presented to them. The second was to have pools of experts, at least in 2 areas of provenance research and science, so that you wouldn't have competing experts. The saying here is you can hire an expert to say anything. And so, which is generally true. And so when you have cases coming down to battles of experts, it can be highly confusing to the trier of fact. But if you have one expert, an expert to the court, which is more in the nature of French and German court models than it is in the US doesn't have this model, but we followed a more European model here. Somebody who their fidelity is to the tribunal and their obligation is to get the right answer. And so if in the course of their report, an error or an omission is pointed out, they won't feel defensive about it because they haven't been hired by one party to basically advocate an opinion. They've been hired by both parties and by the tribunal to get to the right opinion. And so they are charged with the obligation of going back and correcting or amending their opinions. And they have the comfort of doing that. Obviously you can't have a pool of connoisseurs because a connoisseur is artist specific. So parties still would need to go out and try to find a connoisseur, but they're highly incentivized through the CAFA to do that cooperatively, to work together, to identify a recognized connoisseur and have that person be the only expert as well. The third and related concept was a role known as a technical process advisor. And this is somebody who works with the parties to develop a discovery plan that really fits the case and can help the parties, for instance, identify an appropriate connoisseur. Discovery is something that has very, very different dynamics depending on where you are. In the United States, discovery is very liberal, very, very costly, very expensive. And in art cases can be extremely expensive because judges they're not art historians, they're not art experts themselves, and they're afraid of excluding evidence that might be important later. So it doesn't cost a judge anything to say, sure, I'm going to allow all sorts of discovery and hire as many experts as you want. But if you're the litigant that has to pay for that's not so much fun. So we have a technical process advisor who works with the parties to come up with a really appropriately fashioned discovery plan for that particular case. That's really the core ideas and justifications for the CAFA. The CAFA is, we have arbitrators now literally on every continent in the planet except for Antarctica. There are 11 CAFA neutrals located in Brazil alone. And the arbitrations and mediations can be conducted anywhere in the world that the parties may agree. And you could do it by Zoom these days, which is a very effective method, but you can conduct them anywhere. And that's why we have arbitrators and mediators located around the world so that the parties can feel comfortable finding somebody who's going to be somewhat localized to their area of dispute. So that's a little background into authenticity disputes and the founding of the CAFA in particular. And thank you very much again for the opportunity to speak with you all today.
Thank you so much, Bill. We are amazed by your speeches. So we pass the floor to Thomas.
Yeah, thank you very much indeed. And it's way past the witch's hour back here in Europe. So it is late, but I am suitably caffeinated. So I should get through this without a problem whatsoever. Now, first of all, muito obrigado. Many thanks to you both for organizing that, Taina and Victor, and for handling so smoothly with poise and panache the technical issues that we had at the beginning. All good. Now we're on our way. You asked me to talk as well about how I got into art law. So I will do that. That will be the first part of my presentation. But I do talk about it a little bit more in detail. So there will be some case involved in that too. And the second part is then going a bit more towards CAFA as well, basically following on from what Marta and Bill already have said. And the focus is a little bit on the certainty in the art market brought upon by a more certain dispute resolution mechanism that underpins it. Now, let me start by telling you a little bit about how I got into art law. And there's essentially 3 points that I want to share with you. The first of all is there was a general interest, I have to say that, and there were two defining career-defining examples in a way. Now, the general interest is really a long-standing one. It started with me quite interestingly and perhaps a bit unusually with the surrealists, in particular Dali and Magritte, were sort of my cup of tea. Bit of Chagall, bit of Picasso in there as well. And then I moved on to pop art, Warhol, and in particular Tom Wesselmann. That were those sort of the big ones that I really loved as a young adolescent. I remember that I copied Wesselmann artworks on big sheets of paper and hung them out in my room, dreaming of actually owning one day myself. The other thing that I was always very keen on, because I'm a passionate photographer myself, was obviously fine art photography, Man Ray, wonderful landscape photos of Ansel Adams, for example, or Henri Cartier-Bresson, absolutely fantastic. And then, of course, nowadays I live in Delft, and that's the city of Johannes Vermeer, who painted the famous girl with the pearl earring in this very town. But the career-defining examples are actually the ones that, how should I say, propelled my interest in art into the actual area of art law. And I just say two things here. One is Hollywood and one is private international law. So I'm a way back private international law lawyer. And as Bill and Marta as well have already pointed out, that is really quite fundamental and very crucial for art law as well. And my first experience in that regard I had in about 2013, 2012 in Australia in relation to a cultural object that was called the dancing Shiva. It's a Natarajan, as it's called in Indian. And it was bought by the National Gallery of Australia. Now, the gallery bought this dancing Shiva, this cultural object, from at the time, very renowned art dealer in New York, Subhash Kapoor. And of course, the due diligence was done, the provenance documentation was supplied, but there were some questions around it, because one of the experts who looked at the documentation actually said, there's the likely possibility, at least, that this Shiva was stolen. The gallery still bought it. I'd actually remember seeing it on display when it arrived in Canberra at the time, but it was in fact really stolen. And in 2013, the matter got litigious. Was filed in New York, and the Australian government consulted me on 3 issues. There was conflict of law rules relating to possible damages here. There was questions about evidence, how to go about dealing with provenance issues, etc., and the application of the UNIDROIT Convention on Stolen, Illegal, Exported Cultural Objects from 1995, and Marta had already alluded to this international instrument. So that was the private international law angle, but I tell you, there was also a bit of Hollywood in that. Now, the background story to this stolen artifact is really a matter of, let's call it, intrigue. It was organized crime on a large scale. It's Hollywood, it's Indiana Jones on steroids in a way. So in 2011, Mr. Kapoor got himself arrested in Germany. That was a sting done by US authorities with the help of the German authorities. And he was subsequently extradited, I think first to the US and then ultimately to India. Now, when the US authorities swooped on Mr. Kapoor, and in particular on his art gallery, they found around $100 million worth of stolen art and cultural objects in his facilities. But the swoop itself was only possible because a little bit earlier, a gang of professional raiders that were employed almost by Mr. Kapoor had been arrested in India. And they admitted to stealing not only this Shiva, but a whole bunch of artifacts for Mr. Kapoor's gallery. And they also gave evidence about, they refer to it as a sweatshop, which was set up solely for the purpose of forging and falsifying provenance. So this evidence by these professional raiders who went around India and stole artifacts from temples and other cultural locations really brought down what can only be described as an empire of professional looters, of professional forgers of provenance, and black market traders. And the case really shone a spotlight on what I can only describe as a murky yet extremely lucrative market that artworks and cultural objects actually are. And Kapoor's gallery on Fifth Avenue, I think it was called The Art of the Past, if I remember this properly, was certainly at the center of this world. And last year, I think it was the end of last year, Kapoor was actually sentenced to 10 years of prison for his actions. The second example is perhaps a little bit more famous. And this is really a case where Hollywood met private international law, and in this particular case is the famous Adele Bloch-Bauer case, of Adele Bloch-Bauer 1, I should better say, by Klimt. And that was a case, ultimately, when it reached the US courts, where at the center were a couple of issues, but competency of the US courts was one very, very central one. Now, it ended up before the US courts, not originally, but it ended up there, but it wasn't there originally because the claimant, it was Maria Altmann was her name, she actually tried to negotiate with Austria the return of the artwork, which was ostensibly stolen, there was no question about that, to her family. But Austria really dragged the chain very badly. And at some stage, Ms. Altmann tried to sue the Austrian government in the Austrian courts, but she couldn't afford the filing fee of 200,000 euros. And that was a reduced filing fee already, because the Austrian courts have the system where the filing fee is dependent on the actual value of the claim. Now, as I said, the case concerned competency questions. It was a question of application of the US Foreign States Immunity Act. And it was relevantly, I guess, really in a nutshell, a question of international competency of the US courts vis-a-vis Austria's state immunity. The case also concerned actually a question of foreign non-convenience, which is another private international law issue. Now, I don't want to go too much into detail. It's actually quite a complex case, but very interesting. Suffice to say that the US courts, right up to the Supreme Court, actually agreed that the Belvedere Museum, which is a state entity of the Austrian state, engaged in commercial activities in the United States. That was through advertising of exhibitions, as well as showing parts of the collection for profit in the United States at some stage. And these commercial activities triggered an exemption in the FSIA in this particular act. And so the connecting factor was there that also gave US courts competency. It's really, in a nutshell, it's a bit more elaborate than that, but that's really in a nutshell. So the US courts had jurisdiction, and the very first reaction of Austria was like, oh no, we don't want to go into the US jurisdiction, but instead let's do arbitration, binding arbitration in Austria. And Ms. Altmann succeeded in that arbitration and was actually awarded the ownership. She sold the painting to a gallery for $140 million US. Then again, that was the private international law part. If you wonder where the Hollywood part is, well, this story of Ms. Altmann and the purchase or the litigation of the return of this painting became a biopic. I think it's nowadays called The Woman in Gold. It features Helen Mirren and
I think your audio just went off. Yeah, we have a little. And here. Let's wait a little bit if Thomas comes back.
He unfortunately called it the witching hour. He meant it.
Well, while we wait for Mr. Thomas to come back, I would like to use this time to make a question, if I may. I'd like to ask Ms. Cenini, you said that there is a possibility of the owner who has a stolen art, if he or she is in good faith, she or he can keep it. It is something that in Brazil we have a similar thing, not for art, but for property, other kind of properties. It's called usucapião. It's actually the same word. Is there a minimum of time to that happens, like 3 years, 4 years, 5 years? How does it happen?
Okay, yes, thank you, Victor. Yeah, this is a peculiarity of Italian law, and it is very much criticized, to be honest, and I agree with the criticism. So let's start from this point. We have this rule that says that if a movable property is sold from a person who is not the owner of that property to a bona fide purchaser, the bona fide purchaser acquires the property immediately. There is no time, it's an immediate transfer of property. And this is a general rule that applies to all the property of the movable property. And we do not distinguish between cultural or artistic property and any other kind of property. And again, this was very much criticized because people say, and I also said the same thing in a book that I wrote many, many years ago, that this rule was thought for the commercial goods, the goods that must circulate very easily without too much attention in a certain sense. And this rule, it's not does not fit with the cultural property, this kind of property that are not made for circulate so easily. So this is the bona fide purchaser rule. And then we have also usucapio. And in that case, it requires, depending of which is the property, 3 years, 10 years, 20 years. And in that case, the purchaser could be also not in good faith, even if he knew that the owner, the seller was not the owner. So even he knew it, he could become owner if 20 years pass, and so a very long period of time.
Thank you.
Thank you so much for your contribution, Marta. Thomas, I'm so sorry. We are just fitting in a question. Because
sorry that I dropped off. I had actually lost my entire internet today, and I used a neighbor's Wi-Fi, but for some reason that's now too. But I'm going through my mobile phone now, so that should work at least for a couple of minutes.
It's okay.
Yeah. Do you want me to? How do you want to proceed?
You can.
I'm in your hand. Yeah. Okay. I mean, I basically finished this whole first part, introductory part. So I'm going to speak a little bit, maybe then more on CAFA. And as we just heard, both from Marta and from Bill, they have already identified many of the very specific and important aspects that make art disputes so unique and so special in a way. And Bill in particular outlined this really strong case actually for establishing CAFA, the quality of the provenance research, the specialized experts, and the quality of awards that Marta was referring to, because you have specialized arbitrators. The trust that comes with that in a specialized institution, the confidentiality, Article 6 of the CAFA rule, of the actual process that is so important to people. And the whole system, in a way, is also optimized to have an efficient and a speedy resolution of disputes. And we know that these art disputes can be horrendously long. I mean, when you look at Adelbert-Bauer, this Klimt dispute, that was 8 years in litigation, and then another 2 years in binding arbitration, concluding in 2006. And we have other examples, Guelph Treasure, which concluded only end of last year, basically litigation from 2014 to 2022. And I think probably the cake is taken by a Pissarro painting, Rue Saint-Honoré. The parties were Cassira and Bonamissa, and that was 17 years in litigation. So these cases can really run an awful long time. And a lot has to do with the fact that there's a lot of uncertainty around the dispute in itself generates uncertainty as well. Multiple avenues to even relitigate outcomes they don't like, as we had, for example, in the Gelfen treasure, where the party just went off after going through the German Commission on looted art, and then started litigation again in the United States. We have questions of competency of courts, as we've seen, standing of the parties, the application of immunities, as we had in Klimt and also Bonamissa, actually, or the nationality of parties, as in the Gelfen treasure. So the consequence of that, for everyone who knows a little bit about the law, is that any length of time in a legal process, any added complexity also translates into very high costs. And they actually do matter, these costs, even though the artworks themselves are staggeringly expensive. Klimt sold for 140 million. I don't know how valuable this painting would be today. The Gelf treasure is valued at around 100 million. The Pissarro was 65 million. So these are really significant amounts. But by the end of the day, Ms. Altmann, the claimant, could not afford a filing fee of 200,000 euros. And her counsel, or her lawyer, Randy Schoenberg, did not actually take a fee. It was an on-spec case that he took there. Otherwise, it would have actually not been possible to litigate. So there is a lot of uncertainty through these multiple proceedings, through unpredictable outcomes and the quality of decision makers. And CAFA really tried to make a difference, or tries to make a difference in that regard. And I want to look at three aspects of CAFA rules in a bit more detail. How the use of default rules and party autonomy is used in order to create more certainty in the litigation sense, or in the arbitration sense, and with that giving more certainty also into the market. And the first is, and Bill has already spoken about that, is the seat of arbitration, actually. So when you look at Rule 21.7 of the CAFA rules, it's quite specific that the seat in the rules, it's often is actually referred to as the place of arbitration, is The Hague, the Netherlands. So on its face, this is what we call in private international law a very strict rattachement, or connecting link, to the supervision of arbitration through the Dutch courts. And that would make sense in terms of certainty when you think about it. But this strictness would be totally counterproductive to a very international market such as the art market, because not everyone really wants to end up under the supervision of the Dutch courts. That's really the upshot of it. And so this is only a default rule. And when you look at the explanation to the adjunct arbitration rules, for example, in paragraph 14, and a couple of other places as well, paragraph 14.1 states that the parties may agree upon another place of arbitration. And this is consistent actually with the arbitration rules of the Netherlands Institute of Arbitration that looks after CAFA as well. So it is entirely possible for parties to determine the seat of arbitration under the auspices of CAFA in Rio de Janeiro. And then the courts of The Hague would obviously not have supervisory jurisdiction, but the competent Brazilian courts. And there are very important legal and strategic questions that the parties must answer, and choices they must make, preferably as early as possible, because it also can obviously influence the preparation of contracts. But if the choices are made, the parties know where the seat is, and they know that their strategic choices will be respected by the tribunal. And conversely, if they do not choose or omit to make a choice, there will always be a default rule that applies, and that gives the parties the certainty of this express rule over the imprecise art of implying, for example, a choice in the contract. Because that's the reality of, if that is missing, that choice, the court will inquire as to what are
Yeah, we have a situation again. I think it's his internet. yeah, I think there is a problem. So,
Yeah, I am gonna use this time again to
make another question.
make another question, and this time is for Mr. William. Different from Europe, Italy, that the good faith owner still can keep the art. In US is different, right? And in that sense, is there any kind of measure that the owner can take to have some kind of indemnization, or you get it? What I mean?
Let me suggest that Thomas has just rejoined us. Let me suggest continue, and I'll turn to that after, if that's okay.
Okay.
Okay, perfect. Thank you. Thomas? So sorry, but you went off for us again.
You're on mute, Thomas.
We are not hearing you. So sorry, it's on mute. Yes.
Okay, that's an operator.
Yeah.
Operator.
It's fine. It's fine. Now we can hear you. Maybe not. Internet's unstable. So sorry.
While we're waiting for Thomas to rejoin, so if there is in the US, if there is a thief in the chain of title, then and you're a good faith possessor, you have to give it back to the victim of the theft or the victim's successors. Your rights as the purchaser of stolen art are limited.
I don't know exactly how long I was.
So if you're within the statute of limitations where you bought it from, you can get a refund, but oftentimes you're outside the statute of limitations. And so you've got all sorts of problems there. Really, it can be a zero-sum game, like somebody wins, somebody loses. It really can, and one of the reasons I find this area of law so fascinating is because in the stolen art context in particular, you can have two innocent parties, an alleged victim of theft and a good faith purchaser who had no knowledge or involvement in any of this. And how the law decides to assign who should bear the loss in that situation, I find academically interesting as well as compelling. So looks like Thomas is back, so I'll hand it back over to him.
Thank you so much.
Thomas, you're on mute again.
Hang on, sorry. I am back. Can you hear me now? Sorry, my mistake again.
No, it's okay.
Yeah?
Yeah, we can hear you.
Anyway, I basically just wrapped up this this issue of choice of law and how CAFA tries to deal in party autonomy around it in itself. So the second element I want to have a very quick look at is the question of conflict of law rules, another private international law issue. And here, CAFA actually, I think this is a very unique approach that it took. It's a very novel approach. I think it was, Bill, you probably know that better because you were part of these discussions. I think it was not without controversy, if I understood that correctly, to actually include that. But I think it's actually worthwhile. It's striking the right balance as well, I think, in this this context. And I think it makes actually a real difference to providing parties with the relevant certainty. So the idea behind is that the CAFA rules contain an article in Article 42.2 that provides a default rule on the choice of rules of law in their contract, or also subsequently ad hoc. They can also obviously do this later in anticipation, for example, of arbitration. And then the arbitral tribunal is required to actually decide in accordance with the rules of law designated by the party. So that's the default rule. That's a very classic statement or restatement, if you want, of party autonomy, of party autonomy. The parties choose, the decision maker will respect. But I have to say I've seen so many contracts in this area where parties just simply do not actually either think about it or don't even include it properly. So they fail to agree actually on a choice of law. And what then follows is the same that we just had in another context. It's really, really complicated to work out what is actually what was the intention, what the parties actually want. And that's very lengthy, very expensive task. It opens up a whole area of satellite litigation as well, or satellite disputes as well. And this is sort of the last thing that you want. So CAFA actually went down a different path and created or included in its rules a kind of guidance to arbitral tribunal that if there is a choice missing in the contract, the arbitral tribunal can be guided by the CAFA rules in order to determine what the applicable law will be for the purposes of this dispute. And there's two tiers, and the first tier is pinned or is connected to the location of the seller. And if it is known at the time of the transaction, then the rules of that location can be applied by the tribunal. And the second tier is if that principal location of the seller is not known, or it cannot be determined, or there is no sale involved in the dispute or the sale that underlies the dispute, then the choice of rules of law will be the rules in place at the location of the current purported owner of the art object in question. So we have here almost a kind of deeming provision. It's not quite deeming because it's guidance, but it is giving some very specific, some very clear guidance, a very clear connecting factor, and a very clear result that the tribunal can take into consideration, and it is encased into a default, or it's juxtaposed to a default rule that entrenches party autonomy. And together, those two rules actually bring about a very high degree of certainty around the question of which law does actually apply in an art dispute. The third part, or the third point that I want to make, is a little bit different to what I just talked about, but it's also, for me at least, a clear question of bringing more certainty into the realm of art dispute resolution. And I put it broadly, and you will see in a minute why. Now, I want to briefly reflect on the ability or the possibility of hybridizing art dispute resolution processes under the CAFA rules. And this is essentially the melding of two or more established dispute resolution processes into one hybrid process. And that would obviously be done on a careful consideration of a whole range of factors, strategic, procedural, and other factors as well. Now, these hybridizations are absolutely not new. Very, very well known in litigation. We all know courts that refer happily parties to go to mediation, for example. That's nothing else than a hybridized dispute resolution process. And hybridized litigation is actually used in art disputes, and there's currently one on foot that is very widely publicized, and it relates to the Salvator Mundi. This, is it the painting of Da Vinci, or is it not? That's one of the big questions. But at the moment, there's a case involving it, which is a fraud case brought, I think, against Sotheby's, if I remember this properly, by a Russian oligarch. And the court had the first hearing, but then ordered the parties to go into mediation just last month. And I think this mediation is now on foot. So it's used in art disputes already. But let's have a look how we meld arbitration and mediation and how it's done in the CAFA, under CAFA. And when I talk about mediation, I mean the process that is facilitated by independent neutrals, the mediator, that is interest-based and non-adversarial, consensual dispute resolution process, where it's the parties that actually develop and decide on their solution by which they would like to, or by which they want to resolve their dispute. That is very confidential and can produce really lasting and sustainable outcomes. So it's this very classic traditional way of looking at mediation. Now, you do this kind of melding of arbitration and mediation for reason of efficiency, for example, of efficacy and of expedience. And it can happen in various ways. So you could, for example, have a situation where you do arb, med, arb. And so you have arbitration, then you move into mediation, and then you move back into arbitration. You can also start with a mediation and then move into arbitration, or you start with arbitration and finish off on mediation. There is a whole, it's almost like a Legos box, and you can put these things together whichever way they actually suit your particular dispute in order to make it more efficient and effective. And it may be conducted in front of the same neutral. So there's where arbitrators become mediators and vice versa, so-called braided processes, of which I'm very, very critical. But they can also be before different neutrals, and that's certainly preferable. And then they're called sequential or overlapping processes, depending on how they're actually staggered or stashed against each other. But I don't want to go too much into detail. This is also another webinar for you guys, is the hybridization of arbitration with mediation. Very, very interesting topic, and it gains more and more relevance. Suffice to say that these melded processes can really be highly effective. And how far is not featuring or doesn't sport an express rule that would say something along the line that the arbitral tribunal is obliged or encouraged to, at every stage of the arbitration, seek, say, to encourage an amicable settlement of the dispute or individual elements of the dispute. So this would be, for example, we see this now cropping up in some of the arbitration institutions rules for general commercial arbitration. One example is Article 26 of the rules of the German Institute for Arbitration from 2018. They have this rule now in their rules and almost putting a positive spin, a positive obligation on the tribunal to look for opportunities to settle. The CAFA rules work a little bit different, but as far as I read them, they at least require the tribunal or encourage the tribunal to look out for these opportunities. Because when you look at, for example, Rule 50, it very clearly says that parties reach a settlement during the proceedings. The parties may jointly request the arbitration tribunal to record its contents in an arbitral award. So there is a mechanism in it that contemplates settlement. So parties must be able to move into settlement negotiations, and they could technically also be facilitated by a mediator. So there should be no problem. So the CAFA rules definitely contemplate the hybridization of their processes. And when we look at Rule 50 in particular, the hybridization would be you start off in an arbitration, you move into mediation, and then you go back into arbitration in order to record the contents of the outcome of the mediation. Now, this results two suggestions that I have. The first one is in the interest of efficiency of art arbitration. And this efficiency of arbitration is rapidly emerging as one of the salient issues at the moment, I think, in the arbitration world more generally. I mean, we have here certainly in Europe propping up events on increasing efficiency in arbitration everywhere. There is perhaps we are on the verge of almost having an either inherent positive calling on arbitral tribunals to encourage parties to seek chances to settle either their full case or at least issues of their case. And I think that applies to CAFA as well. And the second is that is not limited only, in my view at least, not limited only to arbitral tribunal, but I think also counsel is in a situation or in a position where they always should look out for and consider the possibility to move from arbitration into settlement negotiations, perhaps facilitated by a neutral, if for nothing else than for the benefit of their clients. The CAFA rules, in my view, certainly can accommodate these moves. It's not a problem at all. And it's really something where I think it's professionally pertinent for counsel and tribunal to consider it. Only briefly mention that whether, and if so, at what stage, and in relation to which issues you may move into negotiation or mediation within an arbitration. This raises very important strategic, very important procedural, and a couple of other questions as well. So it is fundamental that clients, as well probably also the tribunals, receive quite sound advice and guidance on when to move, how to move, on what issues to move, so that these very important questions can be answered properly, and appropriate decisions, I suppose, in order to take the dispute resolution process further, can then actually be taken in the context of the arbitration. So just a couple of concluding remarks in relation to my first point. Regardless of how you get into the art law world, it's rich and it's rewarding. It's a lot of fun. It's really interesting. Art law and art dispute resolution are real specialities. This is not just sort of a spin-off of something. That's a very, very specific area of law that requires a lot of knowledge and expertise. They can arise in many ways, and we heard both from Marta and obviously also from Bill how they arise, and that they have very unique features, and they're very amenable to being arbitrated. And I also put here that they also can be mediated without a problem at all. The CAFA is a very specialized dispute resolution institution, and it is calibrated towards a sort of quick and efficient, a very trustworthy and a very certain and final resolution of art disputes. So it caters in that sense to the art market, providing that dispute resolution layer that gives certainty into the art market in one way or another. And with that, I thank you very much for having me, for inviting me. Sorry that I dropped out a couple of times. It's now very late, very long, but I'm very glad that I could just put those couple of thoughts across tonight. Thank you.
We thank you so much. It's amazing. We absorbed so much content, and we became more fans than we are before the event. We were before the event, sorry. So we in the figure of CJA would like to thank you for accepting and for making this amazing event, for explaining so much about the art world and arbitration. We are so delightful, and I think we learned so much today. And thank you, people, the audience that has been with us for this time. And we would like to make an announcement. Please just fill the forms that we sent you in the chat, please. It's important for us to know how to proceed in our future events. Peter, you would like to say something?
I'd like to thank you, all of us, for this amazing event. We are aware of the hour, especially for Ms. Cenini and Mr. Thomas John. The time zone between us is very different. So because of that, we are not having the discussion time that we were supposed to.
Yeah, is it too late?
It's too late.
Any questions?
I would just like to ask you, all of you, if you have any kinds of tip recommendations, that be legal or not, for those who likes this content and wanna get in touch. If it could be a book, a documentary, a movie,
Where
anything.
to search, which courses we can do, and which are the main sources for us to, just deep in this content.
If there are course offerings in art law, I teach it at a university, a law school here. Those are great resources. Also, there are some online resources, the Art newspaper and ArtNet. Often they have regular stories about the market, but they will also routinely run stories about art legal disputes, and you can learn quite a bit from those as well.
Yes, if I can add something, there is an institute that I would like to suggest you, Institute of Art and Law, that is based in UK. And I think that they are really wonderful in providing courses, events, also online, distant learning, and so on and so forth. And Alexander Herman is the director of this institute. I know him quite well, and it's really an expert in this field. So I suggest to have a look to the website and to enroll to the courses. And then, of course, in Italy, we have most of the courses are in Italian, but at my university, we have a course, a master course on tourism and management, where there is a course of art law in English, but yeah, the main topic is tourism and management. And then there are plenty of books. In case I can give you a list of books that I can, which I suggest you to read, and I would love to do it maybe in a later mail.
Yeah, of course. Thank you so much. If the audience has any questions, you can send us an email. Yes, to CJA, and we're gonna respond or send our guests. Thank you so much, Thomas. You'd like to say the final words? Any recommendation?
Watch The Woman in Gold. You know, that's a sure way of getting you started on your way. In that regard. No, look, I can only endorse what Marta and Bill just said. There's plenty of really good courses. There's also more and more coming. My university, Sigmund Freud, they got art law master now. We're in the process that's not with the Sigmund Freud University, of developing a more comprehensive one that brings together various sciences and art and law and others. So the business also. So that's quite comprehensive. There may be some announcements very soon in relation to something else as well. I can send you that once I have more detail on that. Yeah, it is actually, I think, a very dynamic area that is growing now. It was a bit of a niche. I think it comes more to the fore. It becomes more mainstream. As Bill said, these are commodities nowadays that are traded for investment purposes. I was reading the other day a very shocking figure. I can't remember the exact number anymore, but this is by far most artworks are nowadays, I think, in free harbors, and not actually hanging in somebody's living room to look at. But they are in, climate-controlled, very fortified storage facilities, waiting to become even more valuable. And it is certainly growing, and I think it's a good time to start looking into this area and becoming acquainted with it. Yeah,
it's a interesting area. We like to study and discuss about it. So I think it's just the start. Thank you so much for all your contribution, for your patience. So sorry for the technical issues we had today. So sorry, but we would like to thank you so much for the event. It was amazing, really.
It was a pleasure to be a part of it. Thank you.
We should probably one small disclaimer. I don't know exactly how this is for Marta and Bill, but I'll be very honest with you. I can almost not go to an art exhibition anymore without looking at the labels and trying to work, is this actually one that is under a claim that was stolen, that was restituted? It is really, you ask yourself, every single painting that you see that comes from a particular era, of course, is this stolen? Is this stolen? Is this stolen? So it will do something with your mind. You cannot go to a museum anymore and enjoy it really, but no, that's actually true. But it's certainly something that it does to you, but it's very interesting.
Yeah, it is. Thank you so much. And we hope we collaborate in future events. Thank you so much for the audience. Good night, everybody. Thank you so much for your presence.
Marta, and thanks, Bill.
Bye.
Bye.
Thank you. Thank you. Bye, guys.
Bye. Thanks.